Oh. Hello and good afternoon. Sorry, hold on just 1 second. We're trying to get Dr. Asekun back. It looks like he disconnected. Okay, I can't. This is gonna drive me nuts. Well, thank you for joining us today. As you saw, if you were here at the beginning, Dr. Asekun was with us. He's not in the office today, but he will be joining us remotely. Let me see. Try doing. Oh. That's strange. Oh, the lawyer is typing. Let me see. I'm so sorry for the technical issues. Like I said, he's trying to join us remotely, and unfortunately, there seems to be an issue. Yes. Okay, he's going to be rejoining us. So, good afternoon and welcome to our weekly Wednesday podcast. Dr. Asekun will be with us shortly. We apologize that we weren't here last week. Dr. Asekun has been traveling, so he has not been in the office. Oh, there he is. Let me see the volume. Okay, good afternoon. Can you hear us?
Good afternoon, ladies and gentlemen. Yes, I can hear you. Thank you for joining our weekly podcast. This is Dr. Olu Asekun here. Wherever you may be listening, remember to join every Wednesday, 12 p.m. Central Standard Time. That is 1 p.m. Eastern Time. Currently, I believe 1 p.m., 6 p.m. Nigerian time, 7 p.m. in Rome, and 6 p.m. in UK. Today, we are going to continue with our usual style of updating on immigration recent policies. In the meantime, if you have questions, start getting your questions ready. You can send in your questions to our podcast line. Kim, can you please post the number for people to send in their questions?
Yes. And then people can also send in their questions through the live chat.
Okay. You can send in your questions through the live chat. You can also send it through our text line. In the meantime, I'm going to be talking on 3 major updates for this week. I was unavoidably absent last week, so there was no update. So I'm going to combine last week and this week in terms of the updates. There are 3 areas that I want to talk about. 2 of them affect people applying for asylum in the United States, and the third one affects people who are applying for citizenship. For those who have been following our podcast for years, you will recall that during the first term of President Trump, the then Attorney General of the United States, in their sessions, issued a decision known as Matter of LEA2. Matter of LEA2. In that decision, he ruled that anyone applying for asylum under the PSG, that is particular social group, they have to be able to distinguish that particular social group, and it must be accepted socially within the society in question. In other words, it must be whatever the ground of the particular social group must be universally accepted within that neighborhood. It cannot be a story that is peculiar to a particular family. For example, if in your family, maybe they want you to participate in some kind of rituals or something, that cannot qualify you for asylum under the PSG as defined by Attorney General Session in the matter of LEA2. However, that decision was reversed by Attorney General Garland under President Biden. So, last week, the current Attorney General Bondi, recalled that decision in matter of LEA2 and issued a new decision now known as LEA3. So under the new rule, we are going back to the 2019 position. In other words, for you to be eligible for asylum under a particular social group, well, for those who may not even understand what particular social group means, for anybody to be eligible for asylum, you can only apply under one of 5 categories: race, religion, nationality, membership in a particular social group, or political opinion. That membership in a particular social group is the one that is controversial, because everyone in the past has been attempting to make their peculiar situation eligible under the particular social group. Has decided that that is not happening. The second thing I want to talk about, when people start sending in, and I will elaborate more. But the second thing to talk about today, talking in terms of is the BIA decision, Board of Immigration.
Sir?
TCI.
Oh, sorry, sir. You've been cutting
This decision
out.
was issued yesterday.
Dr. Olu?
Okay. Yes, I can hear you.
Okay. Oh, there we go. Now we can
Yeah.
see you. Okay. Okay. Sorry, continue.
Okay. So is it better now?
Yes.
Okay.
Oh,
So as I was
it
saying, the
disappeared again.
BIA, that is Board of Immigration Appeal, issued a decision in what is called matter of GC. This decision was issued yesterday, August 2nd. No, we are in September, sorry. September 2nd, 2025. So under this new decision, the BIA is saying that lack of reasonably available evidence to corroborate an asylum claim may be evidence of lack of credibility, and it will be a ground for denial. Before now, an asylum applicant's sole testimony could be deemed credible, and it could also be a basis for approval for as long as the immigration officer or the immigration judge believes the story. But under this new decision, the BIA is saying that for an asylum to be approved or for the story to be believable, that story must be corroborated, especially when the evidence of corroboration is readily available. So this is going to affect a lot of motions to reopen. So if you have a pending asylum application, you want to do everything within your power to get your evidence ready before you attend an interview or before you attend a hearing in court. The moment you conduct the hearing or you attend the interview, if you bring up any new evidence subsequently, according to this new decision, that will not help you. And for as long as you are unable to corroborate your story, it will be a ground for the denial of an asylum application. The third thing that I want to talk about today as one of the major updates before I go into question and answers is that this current administration is really tightening up citizenship. They are tightening it up seriously. Now, USCIS has announced that they are resuming personal investigation of people applying for naturalization. So what that means is that personal investigation will now involve neighborhood investigations. For those who have applied for federal government jobs in the past, or those who have attempted to join the military, you will understand what neighborhood investigations means. Because now, once you apply for citizenship, USCIS investigators are going to visit your neighborhood. They are going to be asking questions from neighbors, from family members, from religious organizations, from your employers. Even they are also going to be scanning your social media handles or whatever they call that, any information about you from every available source. So, if you live in a neighborhood where you are not friendly, it is possible that your neighbors may not say anything good about you. I'm going, I want you to recall, I think it was 2 weeks ago that I talked about the expanded power of USCIS officers relating to naturalization application. One of the major differences between naturalization application and green card application is the requirement of good moral character. There is no requirement of good moral character in green card application, but there is a requirement of good moral character in citizenship application. So now, what that means is that any negative report from your neighbors, your family members, from your employers, from your co-workers can lead to can lead to a determination of lack of good moral character, which in turn may lead to denial of citizenship application. So, before you apply for citizenship, you may need to review your relationship with your neighbors. You may need to review your relationship with your co-workers, with your employers, with your friends and family, if you intend to become a citizen of the United States under this new policy. Lastly, before I go into question and answer, I also want to mention that this new administration, they have decided to sanction any non-profit organization that is receiving benefits or receiving funding from the government from providing assistance or services to undocumented immigrants. So, both parties will now be penalized, both the undocumented immigrants and the non-profit organizations that are providing services to them. So, if you are thinking of applying for something, even if you are a permanent resident and not yet a citizen, just make sure that uh, you are not attempting to play smart. Whatever you are not eligible for, it is advisable not to apply for it because those things are coming back to haunt people, and we are just starting. Because we have a very limited time, I'm going to go into question right now because I see that we are already 15 minutes into the podcast. So I'm ready for.
Okay. Sorry, were you going to go into the NVC information?
Well, I can't do that today because
Okay.
if I do, I will not have time for questions.
Okay. Okay. So, the first question. Hello, sir. Thank you for all you do. God bless you, your family, your team tremendously. Sorry. Sir, I have someone
Amen.
who was banned from entering into the USA. Now she wants to apply for a Canadian visa. What is the possibility that the ban from the USA won't affect her visa? Can you scroll up a little bit? Sorry. Her visa application. Thank you, sir.
Okay. If I heard you correctly, the question is, what is the probability of getting a US visa having been previously banned? I,
Oh, hold on. Oh, she wants to know if her ban from the USA will affect her Canadian visa.
oh, okay.
Uh,
She wants to know if a ban from the United States will
mhm.
affect the application for US, Canadian visa.
Yes.
Well, as I always say on my podcast, that I'm not 100% sure about. I'm not a Canadian lawyer. I don't know how Canadian immigration law works. So I'm not going to speculate about Canadian visa. However, one thing I know from my experience as an immigration lawyer in the United States is that the Canadian government and the US government, they do share biometrics information. Now, biometrics information is different from immigration information. Biometric information generally generally relates to criminal records. For those permanent residents who have applied for visa in the United for Canadian visa in the United States, you will realize that it is the same application support center where US citizens and permanent residents are fingerprinted. It is the same exact support center that services Canadian embassies in the United States. So I do know for a fact that they share biometric information. But again, biometric information is different from immigration information. Biometric information generally relates to criminal record. So if there is no criminal record, it may not affect the Canadian visa. But again, I'm not an expert on Canadian immigration. But I also want to say that both in Canada and the United States, visiting visas are discretionary. It is not a matter of right, it is a matter of discretion. Under the US immigration law, any application that is discretionary can be denied with or without reason. Even though the Board of Immigration Appeal, in the case of the United States, they have set some standards for immigration to adopt in exercising a discretion. In other words, they want immigration to weigh the positive equities and the negative equities. They put both of them on the scale whichever outweighs the other is the one that will prevail. However, this new administration issued a new policy, I think about 3 weeks ago, telling both DHS and EOIR. You know, DHS include ICE, USCIS, and CBP, as well as the Department of State, giving them directive that whenever there is a requirement of exercise of discretion, they should not exercise the discretion in favor of immigrants. That was a new directive. So anything discretionary right now does not stand a good chance.
Okay.
That's what I will say to that. The next question, please.
Okay. The next question. Good day, doctor. I sincerely appreciate all you do to educate everyone concerning the current immigration matter in the U.S. God bless you and your team. Kindly enlighten me on the process of adoption.
From which country?
It doesn't say, so I don't know how we can answer that without more information.
Yeah, please go to the next question. That question is not complete. I don't want to speculate. Yeah, please go to the next question. I need to, because when you are talking about adoption, there are so many things that are associated with adoption. There are 3 different ways to adopt a child from outside the United States. So, if the person is a U.S. citizen, the first question is the child to be adopted, is that child an orphan? Because there's a different rule with orphans. And secondly, there's a convention that we have to determine where the child is coming from, the country from which the child is coming from. For example, Nigeria as a country is not a member of the Geneva Convention on Adoption. So that rule is not applicable to anyone attempting to adopt a child from Nigeria, for example. But at the same time, Nigeria has its own adoption rule. So we are just going to, I will be in a position where I will just spend a lot of time speculating. So I would rather prefer that I have the specific question, more detailed question, so that I'll be able to provide proper answer. Because like I said, the procedure is completely different. There are multiple ways to go about it, and this is like an open check. If I start answering, we will spend the whole day here addressing that. So please go to the next question.
Okay, the next question. Hello, doctor. I would like to ask how I can track my processing time accurately with the new USCIS flexible system called Service Center Operations, SCOPS, because listing one service center might give a false impression of where my case is actually being processed.
I didn't get the question, please.
So they're asking about processing times, but what you would need to do is go to the USCIS website and go on the homepage. I can put the link in the description of this video where you could go ahead and track, the processing times for cases. Yeah. Yes. Yes. Okay, so we're going to go ahead and post that. So I'll go to the next question. Okay.
Okay, thank you.
Good afternoon, sir. I just got my I-485 employment-based approved. I want to file I-824 follow to join. 1. In the form, the husband is an applicant, not petitioner, right? Do you want me to continue?
You mean the I-824?
Yes, the I-824.
Yes, I-824. Yes, the applicant, the permanent
Spouse.
resident is the applicant in that case.
The permanent resident is the applicant.
The way, Yes, the way to determine whether a particular process is an application or a petition, you look at the title of the form. So when you are talking about form IA24, that is application to application for action on an approved petition. That is the title of that form. So the person filing it is the applicant, not petitioner.
Okay.
If the title is a petition, that's when
Mm-hmm.
the person applying is the petitioner. For example, if you are filing I-130 on behalf of a relative, that is petition for alien relative. So that's a petition. If you are filing I-526, that is a petition. If you are applying to remove condition on permanent resident, that is a petition. So you look at the title of the form itself, but where the title starts with application. For example, green card application is an application to register permanent residence or adjust status. That is the title. So in this case, IA24, the person applying is the applicant, not petitioner.
Okay.
Just a follow-up from that person's
Oh,
name. I forgot to mention on the okay, so this is the last one.
there's a follow-up from.
My question is, I need doctor to explain the scope.
Oh, okay. So
I
should
know
I?
we check the time
Okay.
with the new flexible system. I need doctor to shed more light on that.
Okay. I guess we'll come back to the question I was on.
Yeah.
Okay. Okay.
The next
So
question, please.
okay, finishing up the question from this person. 2, for part 3, it says provide the information of beneficiaries other than you. For people that chose 1C, follow to join, they have to fill 1A through D, form number and receipt. Skip 2A through 4H, then start again 5A. I don't understand the question. Okay.
Please go to the next question. We can't spend the whole time on that.
Yeah, we can't address answers about filling out forms on here. So the person who asked the previous question about the processing time, they were wanting you to explain the SCOPS, the Service Center. What is it?
Service Center Operations Director.
The Service Center Operations Directorate. The new SCOPS. It's SCOPS. They want you to explain that.
Okay. Okay. What that means is that, again, under this new administration, they are trying to clear a lot of backlog. The intent is not something that I want to speculate about, even though everybody already know that the president set a target. There is a weekly or monthly expected number of people that are supposed to be either deported or handled. So, in an attempt to meet that self-imposed target, they are setting up um, a model offices. Not is not a permanent office. Example is the new scope office in, I think, where is this place in Dallas? You know, generally before now, asylum office, asylum
Oh, the
interviews in
Farmers Branch?
Texas are conducted only. Yes, asylum of interviews in Texas are generally conducted in Houston and El Paso. But right now, in order to meet this expectation, they are going to different areas to kind of accelerate the process. So they just set up a new temporary office in Farmers Branch in Dallas to conduct asylum interviews. And what I've discovered from that office is that they are actually not processing and
Oh,
then taking the file back to Houston.
I'm sorry, you cut out.
But in order to, what I said is that that temporary office in Farmers Branch, even though they conducted interview there recently, they are actually not treating the asylum cases in that office. They are taking those files back to Houston. But in order to expedite the process, that's why they decided to come to Farmers Branch in Dallas. So even though they are conducting asylum interviews in Dallas currently, there is still no asylum office in Dallas. The asylum offices still remains Houston and El Paso in the case of Texas. So those new offices were set up to expedite cases.
Okay. Thank you. I think that answered that person's question. I will move on to the next one. Okay. Good afternoon, doctor. My asylum was approved September 2024. How can I go ahead? Can I go ahead and apply for my green card now, even with the hold Trump administration put on the green card processing?
That's a very good question. Now, I'm not going to give a yes or no answer to that question. I'm going to advise this particular person to go back and consult a very experienced immigration attorney, an attorney who is familiar with the current process. Because, to be honest with you, if you apply, if you are granted asylum last year and you apply for permanent resident right now, your asylum is going to be revisited and they are going to scrutinize it under the current rule. So, if you know that you escaped when the thing was approved last year, I will not advise you to apply for anything right now. In the United States, presidential elections are 4 years, for 4 years. Just wait it out. But if you know that everything is okay, you don't have any skeleton, your story will meet the requirement under the current policies. Because it is possible that your story may be eligible for asylum last year and not be eligible right now. And if you apply for green card right now, they are going to revisit that story under the current policy. So, the ultimate decision belongs to the applicant, but in my own opinion, I will wait it out.
Okay.
I have a client who was granted asylum in 2005, and up till now, he has not been able to get green card, despite the fact that we filed the application for green card since 2006. Why? Because a new policy came up and the association that he claimed to belong to, that association was subsequently designated as a terrorist organization by the United States. And because he admitted to being a member of that association, he was not eligible for permanent residence. But that was under a different administration. That was under President Bush, even though the application has been pending ever since that time. But under this current administration, I can assure you they will revisit it and probably revoke the approval of the asylum application. So if you know that your story may be questionable, it is advisable to just hold on to your asylum. Asylum is also permanent. The only difference is that you may not be able to travel to your home country. And of course, you can do every other thing that a permanent resident can do if you are granted asylum. So, if depending on the story, you may need to wait it out. But if your story is straightforward, can go ahead and apply. That would be my suggestion.
Okay. The next question. My EAD came with USCIS error in April. I sent them a mail and sent the card to production as advised, but I have not received a reprint of the card. Every other message and contact has not yielded a result. What do you advise, sir? Do I sue USCIS?
You don't even want to do that under this current administration. You know, I'm a very passionate litigator, and I can tell you that even as of today, I have cases pending in federal court against USCIS, against DHS, against the Department of State. But despite all of that, if I'm to advise anyone right now, this is not the time to file mandamus. You don't want to do that under this administration, because if you do, this is an administration that will go after you. So it is not advisable. You should just go ahead and do service request, or at most, you do what I call congressional intervention. That would be my advice.
Okay. All right. So the next question. Hi, good afternoon, sir. Thanks for your time. Please, is there a limit to the number of times a 2 years green card holder can travel? I just got back from Nigeria last month.
There's no limit. There's no limit, except that you just put your house in order. There is not really a difference between a 2-year green card and a 10-year green card. The only difference is the expiration. The 2-year green card is a conditional green card. It is those conditions must be fulfilled before it can be extended to 10 years. So there are 2 types of conditional green card. One is the green card obtained based on marriage to a U.S. citizen. If your marriage is less than 2 years on the day that USCIS was going to adjudicate the petition, or on the date that you enter the United States with an immigrant visa, then you get a conditional green card. That simply means that they don't trust your marriage. They want to be sure that the marriage is legit. It was not entered into for the purpose of evading immigration laws. So they want you to go and live together for 2 years and then come back to apply. The second type of conditional green card is the one by investors, those who invest huge amount of money to get green cards. Because at the time of investment, a lot of them are making promises. I'm going to do this, I'm going to do that. So USCIS does not want a situation where they will get the green card and then change their mind. So that is why they give them 2-year conditional green card. So that in 2 years' time, when it is time to renew, you will now have to provide evidence that you actually did those things that you promised you are going to do. So generally, the 2-year green card and the 10-year green card, they serve exactly the same purpose. The only difference is the expiration time and the conditions attached to the 2 years. So when it comes to traveling, you can travel as many times as you want. However, if this was based on marriage, you want to be sure that you are on the same page with your spouse. Because if you are not, you may be in serious trouble. I've seen a situation where somebody traveled with a 2-year green card. He was coming back to the United States. The CBP officer decided to call the spouse. And they called the spouse, "Where's your husband?" And the innocent woman said that he's at work.
Yeah.
And this is somebody that was outside the United States and just coming back into the United States. So that clearly shows that they were not living together. That clearly shows that this was not a legitimate marriage. So there could be trouble from things like that. But if you know that you don't have those kind of problem,
Mm-hmm.
You can travel as many times you want, even if you want to travel every month. That's your choice.
Mm-hmm.
It doesn't affect the green card. But the more you travel with your spouse, probably will give you more
Evidence.
legitimacy.
Yeah. Okay. So there was a clarification on the previous question about the EAD. The mistake that they made was the country of birth. So they put Niger instead of Nigeria.
That may not be a mistake because sometimes there's limited space
Yeah.
in those long words. That may not be a mistake. If that is the only thing, I will not even advise him to return it
Mm-hmm.
because that may not be a mistake.
Yeah. Okay. So going on to the next question. So, hello, doctor. Thank you so much for taking the time to address various immigration issues on this platform. May God bless you richly. So, the
Amen.
question, amen. I filed Form I 130 for my wife. The petition was approved May, since May, sorry, January 2025. What? Okay. And the approval notice was sent to me. Up to this moment, USCIS had, yeah, USCIS had not sent.
They haven't scheduled the Wi-Fi.
Okay, USCIS has not forwarded the case to NVC for visa application. I've contacted them and even created a service request, but they've confirmed that they are yet to receive the approved petition from USCIS. Could you please explain the likely reason why they wouldn't, why they have not responded?
Well, if you contact NBC Research, so you should contact NBC, provide a copy of the I-130 approval notice,
Mm-hmm.
and then NVC can actually request the approved petition from USCIS.
Okay. So moving on to the next question. My family's I 130 was approved 6 months ago. When I checked, it shows at NVC, but the priority date is October 17th, 2025, and no call yet. What should I do?
From that information, the priority date is not current.
Mm-hmm.
And until the priority date is current, you can really not do anything because the impression I got from that question is that this is not an immediate family case because for immediate family, priority dates are not required. But
But how
for
is the priority
extended
date? That's a
family
future
members,
date. How is the priority date a date in the future?
that's another challenge with
Yeah,
that question. Maybe
it
maybe the
was a
person who
typo.
asked the question can clarify.
Yes,
Maybe they can clarify. But the
yes.
first thing I want them to clarify is the type of petition.
Mm-hmm.
Is this immediate family petition or is this extended family? What preference category?
Mm-hmm.
F1, F2, F3. For immediate family, priority date is not an issue.
Mm-hmm.
But for extended family, it may be an issue. And that is
Yes.
why it is important to know what category this petition is.
Okay. We have another NVC question. We have a lot of NVC questions right now. Okay. Hi, our case was approved October 31st, 2025. How was October hasn't happened
We are
yet?
not even
Why?
in October 2025 yet.
Yeah. This it's right after that one. Okay.
Go to
Maybe
the
they mean
next
20
question. I don't think that
2024.
one is.
Okay. Uh
Please go to the next question.
okay.
Yeah, that happens. I mean, it takes about a year or so.
Okay.
So the National Visa Center confirmed they were documentarily qualified
So
last year.
NBC confirmed that they were documentarily qualified last year, October. And NBC sent the case to the consulate in Lagos awaiting interview date. Till date, no interview letter has been sent to us. What should we do? Forgot to mention, I am a U.S. citizen who filed for my spouse in Nigeria.
Well, if the petitioner is a U.S. citizen petitioning for his or her spouse, then that petitioner may be eligible for congressional intervention. I mean, I've always said it that election is coming up, and this is the time that people can actually get assistance from the congressman, from any congressman in the United States, especially Republican congressmen. This is the time. So let him just go and request congressional intervention. And because it's an immediate family situation, the chances of getting uh, assistance is very high since the petitioner is a U.S. citizen.
Okay. Let me go to the next question. Okay, so this is a follow-up on the adoption question from earlier. They're saying adoption from Nigeria by a U.S. citizen. What's the process and duration? The child in question is 14-year-old nephew, is 14 years old and nephew to any that lives in the U.S.
Well, that one is going to be extremely difficult to adopt because for several reasons. Number one, family adoption is not as easy as orphan adoption. When the child to be adopted is an orphan, it is much easier to process. They will start by filing advance permission to adopt an orphan, and they will need to get a home service uh, approved home service agency who will conduct investigation into the U.S. citizen family and determine that the condition, the living condition is appropriate for adoption. After which they will send the approved, I think is a N600. Is it 600? No, I600. I think I600A. I think it's I600A. They will send that approval to. You can confirm that form
Yes, I will.
number.
Yes, I am.
I know it's not N. N is for N600 is for naturalization, certificate of citizenship. That's N600.
Yes. Okay,
But the point I'm making here,
I-600A.
yeah, it should be I600A.
Yes,
So
it
the
is.
point I'm making here is that when the child to be adopted is a relative, it is much, much, much difficult to process. Apart from doing the home study, apart from filing the I600A advance permission, they still have to go back to Nigeria to go and do the adoption process in Nigeria. And because of child trafficking, even the Nigerian government have tightened the adoption process. I do know that in some states, it is required that the adoptive parent or the proposed adoptive parent live with that child in Nigeria for a period of at least 90 days,
90
3 months.
days. Okay.
And then, yes, and then when a temporary adoption is granted, the the proposed adoptive parent will live with that child and then determine whether he or she wants to follow up or follow through with the adoption by applying for permanent adoption from the court. Again, a lot of people cannot afford to live in Nigeria. A lot of US citizens especially those who are working here,
Mm-hmm.
many of them cannot afford to live in Nigeria for that long. So what they do is to get relatives, family members in
Mm-hmm.
Nigeria to help them take care of that child. But
Mm-hmm.
again, that adoption application will be denied at the last minute at the US Embassy, because the embassy will not participate in any form of breaking the law of any country, including
Yeah.
Nigeria. So that is why those things are not as easy. So if you are going to adopt, it is better to adopt an orphan rather than adopt a family member. In
Mm-hmm.
addition to the cumbersome process,
Mm-hmm.
even immigration law itself frowns at adopting a family member,
Mm-hmm.
because it is difficult to determine a child that is legitimately adopted
Mm-hmm.
for the right purpose rather
Mm-hmm.
than adoption for the purpose of providing better life.
Yeah.
So I've seen a lot of situations like that where after spending thousands of dollars, spending years processing and all of, at the end of the day, they will still deny it at the embassy for those reasons that I've enumerated. So if you are really going to adopt, my advice would be to adopt an orphan. And in that case, because Nigeria is not a member of the Hague
Egg.
Convention,
Mm-hmm.
yes, they can do the I-601A,
Mm-hmm.
advance permission to adopt a child. Once they successfully go through the process of home study and all of that, they don't need to live in Nigeria for too long.
Mm-hmm.
And of course, once this one is approved, that adopted child becomes a US citizen as soon as he or she is brought into the United States. And of course, adoption has to be completed before age 16. Once the
Mm-hmm.
child turns 16, adoption may not be approved at that
16?
stage. Yes, age 16. The
Oh,
only
okay.
exception is if the family is adopting a sibling and
Mm-hmm.
one of them is under 16
Mm-hmm.
and the other one is above 16 but under
Oh,
18,
okay.
because the family is adopting both of them, they will
Mm-hmm.
still allow them to adopt the one that is over 16.
Okay.
But that is the only exception. Otherwise, adoption must be completed before a child turns 16.
Okay.
And there is also a 2-year residency requirement.
Yes.
This is another area where a lot of adoptive parents
Mm-hmm.
in the United States, where they face difficulty
Mm-hmm.
bringing adopted child to the United States. After adoption,
Mm-hmm.
the adoptive parent must exercise parental control over the child for at least 2 years
Mm-hmm.
before they can petition for that
Mm-hmm.
child, especially
Yes.
if they are going to go through the I-130 application process.
Uh-huh.
Next question.
Okay. Uh,
If this person still have additional question on adoption, we have a podcast that specifically addressed adoption.
yes. Yes, we do.
So they can go back to our YouTube channel and check all those podcasts on adoption.
Mm-hmm. Okay. Next question. Good morning, Dr. Olu. Thank you, sir, for all you do. May God continue to bless you. Amen.
Amen.
I I am a 10 years US green card holder, which makes me a US permanent resident. I was issued my card in December of 2024, but now divorced due to some irreconcilable differences. I got remarried in May of this year. Please, sir, are my Am I eligible to file a spousal petition for my husband who lives in Africa? Thank you for your response. God bless you.
No, no. That is a major red flag.
Mhm.
That is a major red flag. If when I say no, that doesn't mean that I'm saying that it is not legal. It
Mhm.
doesn't mean that it is not something that is legally possible.
Mhm.
Yes, it is legally possible. But when I say no, it means it is not advisable.
Mhm.
It is not advisable. In fact, to be honest with you, in my opinion, getting married in less than a year after getting the green card through, okay, maybe I take that back because the question didn't clarify. How did he get the green card? Was this based on marriage or was it based on employment?
So,
Or was it based on humanitarian consideration?
based on what they've
Because
said,
you can only get green card in one of four ways. You can get green card through family petition. That is family based. You can get
mhm.
green card through employment. Either your employer is your sponsor, or you file a self petition, or you file as an investor. All that is still family based. You can also get green card through humanitarian consideration, which is in the case of people who are granted asylum, or people who are victims of trafficking, T visa, or people who are victims of criminal activities, U visa. And then lastly, you can also get green card for those countries that are still eligible for visa lottery, DV lottery. So those are the four ways. So out of those four, if the green card was obtained based on a marriage to a U.S. citizen, and then you got the green card in December, you divorced almost immediately, you remarried by May, less than 1 year, that will raise a red flag as to the legitimacy of the marriage to the United States citizen. So
Yeah, I
that
just
is going
got
to create
confirmation
a problem.
it was through marriage that they got the green card. The husband who had petitioned for the person asking the question was a naturalized citizen.
That is going to pose a major question, because it's going to raise a red flag. Because if you obtain your green card based on marriage to a United States citizen, and
Mhm.
then in less than 6 months after you got the green card, you you divorce the U.S. citizen, and then you remarry another person. That is evidence of well, I'm not going to say fraud, but it raises substantial question as to the legitimacy of the marriage. Because the
Mhm.
question is, if this green card was approved in December of 2024,
Mhm.
what time did he have time to date the new spouse?
Yeah.
When did they start dating? When did they? I mean, for somebody to get green card through a marriage, December 2024, and that
Mhm.
person is already remarried by May of
May.
2025.
Yeah.
To be honest with you, that person will have a hell of a serious challenge keeping that green card, because that is going to be what I consider substantial evidence of marriage fraud.
Mhm.
It doesn't mean that it is not surmountable. I
Uh-huh.
don't know the detailed facts
Of the
in
case, yeah.
connection with this person. I
Mhm.
don't know what kind of evidence that they have. I don't know whether the marriage produced children. I don't know if they have substantial evidence of relationship. But one thing I can tell you is that the BIA has made it very clear, matter of faith,
Mhm.
there must be substantial and probative evidence of fraud
Mhm.
before immigration can conclude that one entered into a marriage for the purpose of evading immigration laws.
Mhm.
But generally, if you get green card December 2024 based on marriage to U.S. citizen, and by May 2025 you are already divorced and you have remarried another person, I tell you that will be substantial evidence of marriage fraud, because Generally, I mean, you put yourself in the officer's position.
Mm-hmm.
If you just got your green card December, when did you have time to date your new husband? How long did you date? When
Yeah.
did you even meet him? Were you already dating the person while you are married to the US citizen? I mean, these are legitimate questions that
Mm-hmm.
anybody will ask.
Yeah.
So for those
Because
reasons,
December is when they got the
contemplating
green card.
filing, yeah, contemplating filing a petition for the new husband is an indirect way of saying that you want this green card to be revoked. That is my opinion.
Okay. So let me see.
Next question, please.
Yes. Hello, doctor. My U.S. citizen daughter filed I-130 and I-485 for me and her mother since February 2025. We received EAD. How do we know the I-130 is approved or not? Thank you, sir.
Yeah, you can use the receipt number to go to our website, or
Mm-hmm.
that they can go directly to immigration website,
Mm-hmm.
or if they don't know how to navigate it, they can go through our website, Olu Asekun.lawyer, click on resources, and
Mm-hmm.
then click on check the status of your case. Then have your receipt number ready, put in the receipt number and click search. It will tell you whether the petition is still pending or whether the petition has been approved.
Okay. Next question. Okay, there was a follow up on one of the NVC questions. It says that they did contact the NVC since May. They said that they will contact USCIS and get back, but they have not till this moment. So I believe that's when you said to do the congressional intervention. So I believe you already answered that. Let me move to the next question. Thanks for all you do, sir. Please, what happens to a deportee's investment in the United States, especially mortgage and finance?
Well, I will need more information to answer that. Is
Mm-hmm.
this person married? Does is the family here in the United States? Are the family, are they staying behind, or are their friends? I mean,
Mm-hmm.
because the truth of the matter is that once, for as long as you continue to pay the mortgage,
Mm-hmm.
your property remains your property. You don't necessarily need to live in the United States in order to own a property in the United States. You
Mm-hmm.
don't necessarily need to have a green card or be a permanent resident or be a US citizen in order to have property in the United States. So as far as owning properties and assets, it remains yours for as long as you are paying your mortgage. So the question is, do you have family here? Do you have friends who can help you continue making that mortgage payment? Who can help you maybe rent it out or use it for Airbnb or whatever you choose to do with it? This has
Mm-hmm.
nothing to do with the government. It has a lot to do with the mortgage company. So
Mm-hmm.
for as long as you keep paying the mortgage, you are still the owner of the property. And even if you choose not to pay the mortgage, you can choose to sell the property. You
Mm-hmm.
can still sell a property without living in the United States.
Mm-hmm.
If you get a realtor to
Mm-hmm.
list the property, if the property is sold, you will sign for the title company at the US embassy in whatever country you are in.
Okay.
If you are living in Nigeria,
Uh-huh.
the US embassy in Nigeria can serve that purpose.
Mm-hmm.
You go there, the title company will send the information, the closing document to the US embassy in Nigeria, and you go to the US embassy to go and do the closing.
Mm-hmm.
So that is all that is required. So the fact that you are deported does not deprive you of the ownership of your property.
Mm-hmm.
But if you miss mortgage payment, that can create problem because the property will be foreclosed.
Mm-hmm. Okay. The
Next question, please.
next question I can actually answer real quick. The person said, "Hi, under the new administration, is I-864W for immigration or for immediate relatives for children being used? If so, it can't be found on the USCIS website." The answer to this form is no longer in use because they have updated the questions on the I-485 to cover the questions that were previously covered under the I-864W. So, no, that form is no longer in use. Okay, I'll go to the next one for you.
Thank you.
You're welcome.
Thank you. Next one.
Yes, good afternoon, sir. God bless you and your team for all you do.
Amen.
Can a 2-year green card holder petition for her dad? Also, after receiving the green card, must you change your driver's license and social security? Thank you.
Well, let me answer the last part of the question first.
Uh-huh.
The answer to that is yes to both of those things. Once you get the green card, you need to go to driver license office to go and
Mm-hmm.
update your record. You
Mm-hmm.
also need to go to social security office to go and update it because the social security and the driver license given to someone that is not a permanent resident, they do have annotations.
Mm-hmm.
For example, in the case of the driver license, in some states they write something like limited term on
Mm-hmm.
top of it. So in order to get that limited term removed, you need to go back to driver license office. In the
Mm-hmm.
case of social security, they do write on the social security card, valid for employment with DHS authorization only.
Mm-hmm.
Again, this is something that you need to have removed on your social security card. So you need to take your green card to social security and driver license offices to update them. Now, going back to the question of petitioning for your parents,
Mm-hmm.
that is not possible. One of the major differences between a U.S. citizen and a permanent resident is that a U.S. citizen can petition for parents.
Mm-hmm.
Permanent resident cannot petition for parents.
Mm-hmm.
A U.S. citizen can petition for married children.
Mm-hmm.
Permanent resident cannot petition for married children. A
Mm-hmm.
U.S. citizen can petition for siblings.
Mm-hmm.
Permanent resident cannot petition for siblings.
Mm-hmm.
A U.S. citizen can petition for a fiancé.
Mm-hmm.
Permanent resident cannot petition for a fiancé. So it does not matter whether the green card is 2 years or 10 years. A permanent resident cannot petition for parents. That is exclusively for U.S. citizens. Next question, please.
Okay. Next question. If a person waiting for follow to join consular interview date gives birth before given an interview date, what do you suggest the person do, sir? It's a country in Africa. They did not specify which one.
Well, they just need to update the U.S. embassy in the country where the interview is scheduled. They need to go with the birth certificate of that child. Since the question is about follow to join, so I'm assuming that the main applicant is a permanent resident because the answer will be different if the petitioner is a U.S. citizen. If the petitioner is a U.S. citizen, that child automatically becomes a U.S. citizen. They will
Mm-hmm.
just need to do what is called report of birth abroad at
Mm-hmm.
the U.S. embassy. But if the main applicant is a permanent resident, that child is not a U.S. citizen.
Mm-hmm.
So, and they do not need to file a separate petition. All they need to do is to update the information at the U.S. embassy,
Mm-hmm.
notifying the embassy that the beneficiary
Mm-hmm.
now has a new child. And of
Mm-hmm.
course, they must provide the birth certificate of that child.
Okay. I
Next
think
question, please.
this is going to be the last question.
Okay.
or sorry, two more. Okay, so one is a follow-up to the one that typed October 17th, 2025. So they said, "Hello, sir. I'm sorry I was in haste while typing. My case is immediate family case. Priority date is October 17th, 2023, but no call for interview yet."
It, it cannot be okay if it is immediate family. Is the applicant a permanent resident? It cannot be a U.S. citizen
Yeah.
because a U.S. citizen immediate family does not go through visa bulletin.
Yeah.
They are exempt from visa bulletin requirement if the petitioner is a U.S. citizen. However, if the petitioner is a permanent resident, then the issue of priority date becomes necessary. So since the priority date is not current, there is really not much that the applicant can do right now. You will have to wait until the priority date becomes current.
Okay. Let's see. Okay, the
So
last
this
question.
next question should be the last.
Yes, this is the
That should
last
be the last
question.
question for today.
Yes, it's the last one.
Okay.
Hello, doctor.
Okay.
I filed Form I-130 for my wife. The petition was approved since January 2025, and the approval notice was sent. The case has not been moved to the NVC for visa application till now. I've contacted them and no reason was given. NVC has also confirmed they did not receive the approval notice. What should I do?
You can do a service request with USCIS. You can also send a request to NVC for them to request the file from USCIS directly. However, if any of those does not work, then you should do what is called congressional intervention. I believe somebody else asked that question previously, so it's the
Yes.
same answer.
Yes.
So I believe that should be the last question for today. As you can
Yes.
see from the background,
It's very
you will see
dark.
that it is dark. Where I am currently is already 8:12.
Huh? Oh, I think you cut out. Hello? Sir? Well, it appears that Dr. Shekun is frozen, but he was about to be signing out. So I will go ahead and say thank you so much for joining us today. Again, we apologize for any inconvenience that we made because we were unable to do the podcast last week. But I believe we should be able to return next week by God's grace. So again, thank you so much for joining us. I do want to... Oh.
I hope to see you again
there
next week. Until then, keep safe.
And
avoid
stay out of trouble.
Stay out of trouble. This is yours truly, Dr. Olu Asekun. God bless you. See you next week.
Thank you. See you next week.